Judge McAfee gave us a 2-week notice that we were going to see a decision be made on whether or not the Fulton County District Attorney's Office would be removed or disqualified from the Georgia elections interference case. We're at the end of that 2 weeks, and the decision is imminent. This is Antoine Anderson. You are watching the Ujamaa Network. Let's get into it. While we were all waiting for the decision to come down about the disqualification, Judge McAfee actually dismissed 6 of the charges against Donald Trump. Most of those charges are involving violation of oath of a public official, solicitation attempt. That's what was being reported as the certain charges that were removed. 6 of the 13 or so that he was hit with. There still leaves the RICO charge intact, according to Judge McAfee. So the case does go on. So that was a surprise ruling that came from the judge's bench before we even get to the question of whether or not DA Willis will be removed from this case. It is also interesting to note that Judge McAfee left the door open for the wording of those 6 dismissed charges to be reintroduced at some other point in time. Why is that consequential? Well, if your intent 2 or 3 days later after making this surprise ruling was to clarify some aspect of the law, why would you go through the process of making that suggestion if the district attorney was in fact going to be disqualified? It does strike me as a little strange, but hey, we're no legal experts here, but it was worth noting, because essentially what will happen if the district attorney is disqualified, that means this case stops. It is halted until a new venue can be picked. And in the political nature of this state, that could mean presumably the end of this case. It's just that critical. And the stakes are ridiculously high for DA Willis. This is an election year for her. This disqualification case will have long-lasting effects if she is in fact disqualified. This will be something that her opponents in the election will pounce upon, should she even attempt to run for another term as Fulton County DA. The ramifications are just enormous. Now, if she isn't disqualified, it is going to spell trouble for the remaining defendants in this case. There is going to be some biblical retribution going on after what this individual endured during the salacious details of her romantic affairs being aired out before the public. Got me thousands of views, I might add, just on talking about the charges. But let's keep in mind what the charges were about. It was about enriching herself by paying Nathan Wade so much money, so much more money, as it is alleged, than the other prosecutors in this case, and then using those funds to go on lavish, expensive trips. That's what's being charged. But listen to how those charges were refuted in a Georgia hearing featuring none other than the person that brought the charges to, or the motion to, Judge McAfee's court, Ashley Merchant.
Which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that in some kind of way this creates a conflict of interest. And of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
Page are you referring to?
Page 24.
Page 24. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification. held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially, to answer your question, that first of all is physical precedent only. So
right.
yes, and we
But you did cite it.
And said that it's physical precedent only.
And you're using that as the basis, really, to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have a case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution, and that was an amusement, prosecution. In that case, that was a contingency fee case. So
that's
was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case because there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where, if that was a forfeiture case, I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
They don't get money for bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer.
Now, even after that serving of word salad, we got to the meat of it. Where's the conflict? You can't say that he's getting enriched by a conviction. He hasn't had anything to do with the defendant. His money comes on the front end, meaning that he's getting paid whether they win or lose. So where's the conflict? Also, what came out in this hearing is that it was Nathan Wade who actually offered her client a plea deal, which was rejected. That's right, Michael Roman was offered a plea deal in this hearing, and it was just turned down by Ashley Merchant, which begs the question, what are we doing here? Take a look.
So Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end. It would be no more billing on that case because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
I mean, checkmate. You're arguing on one end that Nathan Wade is enriching himself through this lucrative contract with the Fulton DA's office, but at the same time sabotaging his own self-interest by cutting a plea deal, thus shortening his money. You can't have it both ways. This one hits at the heart of this motion. And I wonder if Judge McAfee is listening to this. It probably won't matter, but it just seems kind of weird that you would have a conflict of interest where there was none, number one. And even in your citing of this potential conflict of interest, he's the one person that's offering, the first person to offer your client a plea deal, so we don't even have to charge him. I don't know how this is going to go. We don't make any judgments here. That's up to Judge McAfee. We're going to probably find that out tomorrow. Let me know what you think in the comment section below. I would love to hear from you. Keep it clean, keep it honest, and I'll talk to you later.